Yes, sir.
All right. Then we're ready to proceed. I'm going to, even though this was initially begun as a child support matter and Ms. Hewitt was listed as the plaintiff, the matters that we now are dealing with are all brought by your client. So we're going to allow your client to have the first say in the matter. He'll proceed. He'll have the burden to show what needs to be done in the case. So, Ms. Hendrickson, do you wish to make an opening statement? All right. The case that's going to be heard will require testimony, and as a result, if you are going to be a witness for either side in this case, you must go outside of the courtroom and remain outside of the courtroom until you're called to testify. You are prohibited from discussing the testimony of any other witness with anyone or from watching the proceedings which are being live streamed on YouTube, and violation of that order would not only constitute contempt of court, but it would bar you from testifying. All right. If you're a witness, you must go outside. You have witnesses that need to go out?
Judge, I would request the 12-year-old Miss Sophie also. I'm not sure if she's going to be called to testify.
Not testifying.
That's fine.
So whoever's in this courtroom is not going to be prohibited, is not going to be allowed to testify unless they're a party at this point. So,
Judge, just to clarify, the contempt actions that we filed previously, those have been dealt with. So the only thing that's before the court is basically the final hearing, the establishment of parenting plan. And so I'm hoping that it will not take very long today. And so just a brief procedural history, since this case has been going on since last year. As you've stated, Judge, back in March of 2024, my client has filed a petition for paternity in response to a child support action that was filed against him, where he was ordered to pay $800 per month. In May of 2024, he was confirmed as a biological father following a DNA testing. And then in July 8 of 2024, he filed a motion for a temporary parenting plan on the basis that Ms. Hewitt was not being cooperative with visitation time with him. And that was heard August 31st of 2024, where Your Honor ordered supervision at the mother's home. And I believe that this was largely based on the fact that the mother claimed that the child had medical issues, heart conditions, nonverbal autism, and things of that nature. And so you were not comfortable with father having unsupervised visitation at that point. And so father attempted to have visitation from August 31 all the way to November 19 when I was hired in this case. From August to November, father had difficulties with this supervised visitation, resulting in us filing for contempt actions and motion for Christmas visitation. That was heard November 19, and Your Honor did allow my client to have unsupervised visitation overnight. That was for the Christmas time, but kept the same visitation for my client.
Buckle up, guys. Today we are diving right into a heated courtroom session where the judge wastes no time setting firm ground rules. He reminds everyone that the father, not the mother, carries the burden to prove his case. The atmosphere is tense as the judge clears the courtroom of potential witnesses, signaling this is going to get serious. As the father's attorney opens with a timeline of DNA proof and parental rights, you can already feel the conflict brewing beneath every word.
And that day also, the mother maintained all of her claims that the child had some rare condition. He was going to therapy throughout the week. He was getting speech, OT, ADA, physical therapy. And so based on that, again, my client stayed in that same visitation. And so then we fast forward to January 29, At that time, I had subpoenaed all of the medical records and the TEIS, the Tennessee Early Intervention records, and the school records. And we had a hearing January 2029, resulting from our motion to appoint my client as a temporary parent, primary residential parent. At that point, we were so concerned of what we found. And in that hearing, Judge, you did found that Mrs. Hewitt had delayed access to certain services with TEIS for about a year: physical therapy, speech therapy, developmental therapy. There was an ophthalmology consult that was not done for months. Ashton had a cardiology appointment that was not done. Well, baby checkup, and that's in the order, Judge. And so at that point, Your Honor did not find that Ms. Hewitt was credible in her testimony, and you appointed my client as the temporary primary residential parent, and then awarded Ms. Hewitt a weekend visitation, and the child support was suspended at that time. February 25 of 2025 of this year, Ms. Hewitt then hired an attorney. We had to file a second criminal contempt because at that point, your order was for Ms. Hewitt to return the child after her visitation to Mr. Fenton. And by May 14 of 2025, you heard two motions, actually three motions, all of my contempt motions, and Ms. Hewitt's motion to reconsider the January 29, 2025 motion. You denied that motion to reconsider, and then you found Ms. Hewitt guilty of 2 counts of criminal contempt, specifically. That was 2 days in February where she refused to return the child. And you had suspended the 20 days of incarceration at that point. And then you also, Judge, modified the pickup time from 4 p.m. and my client was supposed to pick up. So that way we prevent, further issues. And then also on that day, we were supposed to be heard on this motion for the permanent parenting plan. But because Your Honor was considering the fact that the lawyer was just hired that time, that you were giving him some time to get acclimated with the case, you continued that, and then here we are today. And so, Judge, our goal is to finalize this case and finalize the parenting plan.
All right, guys, this part sets the tone for the storm ahead. The attorney lays out a history of frustration, the father's attempts to see his child blocked by the mother's claims of medical crises. He's been ordered supervised visits at her home, with the mother insisting the child has major health problems. But something doesn't add up, and the court seems to sense it. It's clear the father's legal team is preparing to challenge the credibility of every claim she's made.
And also, Ms. Hewitt, obviously, his lawyer had withdrawn by July of 2025. It's been well over the 30-day period that you gave her, so she hasn't hired a lawyer, obviously. We had filed a proposed permanent parenting plan initially, but that has now changed, and so I am going to present an amended one just based on the recent events that happened in the interim from May when we were here to today. The proof will show that Ashton, he's 4 years old now, he's done tremendously in a good way. He's gone to school, he's updated with all of his medical needs, he has been adding to his vocabulary, which is great. He's gaining friends. He's very close with his teachers. He's just overall has become healthier. His eating habits are better. And so it's been great for this child since father has taken over the overall decision making. In contrast, Judge, mother continues to engage in hostile communication with my client. She's making derogatory comments. So mother's visit started February 7 of 2025, every other weekend. So she would have had 15 weekends from that time. Out of the 15 weekends that she was awarded, she only exercised 5. Out of that 5, the last day, she had only exercised 1 overnight because the following day, the children had to be taken to the grandfather's home. The DCS was involved, police was involved, and we'll get to that. So we have the police officer as well, subpoenaed to testify. The very first weekend that mother exercised her visitation on February 7, that was when you found her guilty of contempt because she refused to return the child to the father. February 21 was the second instance of her visitation. The same situation, refused to return, and my client had to drive 1.5 hours to Tennessee to pick up. And so that was another contempt finding. And then she visited May 30. She was late, but my client accommodated. It was supposed to be 4 p.m., but she came at 6:30. And then the next one was June 13, and then the last episode was August 8. And August 8 was the day when the DCS and the police were involved in the situation. The proof will show that August the 9th, Saturday, the Department of Children's Services were called. There was an anonymous call put in. Apparently, Sophie, the 12-year-old, who is the other daughter of Ms. Hewitt, had made some complaints of abuse. There was some Adderall situation there that will come out in the proof. The environment itself was, the house was unkept, and we will have photos to show of that. There was some environmental neglect allegations. And so it resulted in the children being taken to the grandpa's home. And then my client got a call from the Dixon Police Department asking him to pick up the child. And so my client had to drive again. He was on vacation at that time on a Saturday to pick up his child. So the visitation was cut short.
Here's where things take a sharp turn. The attorney presents hard evidence, medical and school records subpoenaed to uncover the truth. Then, the January 29th hearing becomes the breaking point. The judge finds that the mother delayed her child's access to vital services for nearly a year, a serious red flag. As a result, the father is named temporary primary parent and support payments are suspended. This is the moment the balance of power completely shifts in court.
All throughout, from February to today, mom has never checked on the child, never sends any message to dad what's going on with Ashton. Maybe she doesn't have a ride to pick up, but doesn't even initiate any video calls whatsoever. In contrast, my client has been cooperative, bending over backwards to accommodate Ms. Hewitt. And so, Judge, we do have a lot of concern. And the other thing is the diet that's being fed to Ashton. It's going to come out as well in the proof. And so I know that it is very drastic, but in our proposed permanent parenting plan, of course, we're asking that Mr. Fenton remains the PRP with exclusive decision-making. He's doing a great job. Our concern is Ashton. If he continues to stay in this environment, the environment is not healthy, and we'll show the photos. And the other things, the situation with Sophie, it appears that Sophie has been tasked to take care of Ashton every time Ashton is there, and mother just does not participate. My client is asking that mother's visitation just occur in the county where he lives right now instead of overnight, unless Ms. Hewitt can show otherwise, that she's fit and capable. And we're asking Friday from 5 p.m. to 8 p.m., Saturday and Sunday 8 a.m. to 6 p.m. And these are the same schedule that Mr. Fenton had when he had to come here. So I feel like it's only fair that she gets the same. And we're asking that mother is to pick up and drop off from Mr. Fenton's home. We ask that applies day to day. And then for the summer, my client is asking that he gets at least 2 consecutive weeks for the first and second months of the summer. If the child support is assessed against the mother, which I believe it will when I calculated it, I do not have credible evidence of Miss Hewitt's income just because I've not received any discovery responses that I propounded, whether she was pro se and whether she was represented. And so we would ask that the income be imputed per the child support regulation. However, Ms. Fenton does acknowledge that Ms. Hewitt will incur travel expenses and he wants her to see the child. And so he is willing to waive whatever child support, if any, is assessed against Ms. Hewitt.
Now we reach the fallout. The attorney recalls how the mother was found guilty of 2 counts of criminal contempt, while the father quietly kept his focus on the child's well-being. The contrast is striking. Under the father's care, the child is thriving, progressing in school, and finally getting medical attention. The mother, on the other hand, continues sending hostile messages. The courtroom tension rises as the judge sees who's truly putting the child first.
He will provide the insurance. He will continue to do that. And then we're asking that he claims him for the tax purposes. So in summary, Judge, we're asking if we apply the best interest factors here. It's truly unfortunate that we had come to this point. We were hoping that things will get better, but instead it got worse. And so we're asking that when the court applies the best interest, it finds that majority of them favors my client and that he remains the PRP and that no overnight visitations be awarded to Ms. Hewitt at this point. That's what I have, Judge. Thank you.
Ms. Hewitt, you are representing yourself, your prior attorney having withdrawn. You have the right to make an opening statement, but I'm going to give you a chance to testify. Do you want to just reserve what you want to say when you testify?
I would like to get a few things straight.
All right, then come on up to the podium and you can tell me whatever you want. This opening statement is not evidence. The evidence will be presented in the form of testimony, but I'll give you a chance to respond to what Ms. Hendrickson has said.
Ashton was never out of school or I've got his schoolwork, his attendance, his IEPs, everything, his doctor's appointments. Now his cardiologist switched to different companies. So we were in the process of switching from Dr. Bruns's pediatrics cardiology to another one. But I've got all his school, I've got his school pictures. He was getting ABA, physical therapy, occupational therapy, everything, every day. In TEIS from birth, there was never a gap except when I switched from TEIS to the Dixon County Board of Education. And I mean, there wasn't like a month lapse or a week, or we just switched.
Now you have your daughter here to testify. She's not going to testify because she's in the courtroom. Why do you have her here to sit in and listen to the testimony that's going to be presented?
She wanted to come for.
Do you think it's in her best interest for her to listen to the things that you've heard Ms. Hendrickson, what she says that they're going to present? Do you think it's in your daughter's best interest for her to be sitting in here and listening to this?
This is where the real drama hits. The attorney reveals the mother's repeated no-shows for visitation and the shocking August 8th incident that pulled in both DCS and police. The details are disturbing: complaints of abuse, a messy, unsafe home, and children temporarily removed for their safety. The father is summoned by the police to pick up his child. It's a chilling moment that makes the judge lean forward, because from here, the evidence is about to speak for itself.
Now I know, no, I don't think it is.
Well, then let's have her step outside and sit in the,
Yes, sir.
there's a lobby area that's quite comfortable. She'll
And
be
her
able to sit
cousin's
out
out
there.
there.
All right.
I guess that's all I have to say right now. I don't know what else to do.
All right, let's have a seat. Mr. Fenton bears the burden of showing why he should be the primary residential parent on a permanent basis, so we'll go ahead and let him present his proof. Ms. Hendrickson, you call your first witness.
Beaver, yes. Thank you.
Officer, if you'll step right up here, please. Ask you to raise your right hand and be placed under oath. Pull the base of that microphone up towards you there. That base will slide if you can pull the base of it towards you.
I think that's good.
Thank you. Good morning, officer. Would you state your name for the record, please?
Officer Brandon LaPever, Dixon Police Department.
Okay, so you're employed with the Dixon Police Department, is that right?
Yes, ma'am.
And what is your position there?
Patrol officer.
Okay. And are you familiar with the parties sitting here today?
Yes, ma'am.
Okay. And did you come upon them on August the 9th of this year?
Yes, ma'am.
Okay. And then will you tell the court what was the reason for your, so you had an interaction with which party?
Miss Hewitt.
Okay. And so tell the court why you had an interaction with Miss Hewitt.
On the 9th, we received from dispatch a complaint and calling in, asking or reporting poor living situation for the children. She asked that we do a welfare check. I spoke to her a little bit, just explained to her what we could do. We could do a welfare check on the child, and she asked that we do that.
Okay. And who had made that call?
I believe it was if I recall correctly, it was the aunt of the Miss Sophie.
Here we go. The courtroom gets real as the first witness takes the stand, Officer Lever. He describes walking into a home full of clutter, chemicals on the floor, and unsafe conditions for the kids. Every word paints a picture of neglect that shocks the room. The officer's calm tone only amplifies the seriousness of what he saw. This testimony solidifies everything the father's side has been claiming and leaves the judge with little doubt about who's been protecting this child.
Okay. Okay. And then and what happened next? Did you proceed to check
So
on
we
the
proceeded
home?
to 313 Martin Luther, make contact with Miss Sophie, and I'm not familiar on the other child's name. The little boy that was there with her.
Okay.
We made contact with them outside, and asked if their mother was home. I believe she called her mother on the phone, and then I went inside, spoke with the mother, and Officer Martin stayed outside and spoke with Sophie.
Okay. So when you got there, did you testify that you encountered Sophie and the little boy? Is that right?
Yes, ma'am.
Just
They
the
were
two of
outside.
them?
They were outside, and the little boy was playing in a pool with some bubbles, and mother was inside.
Okay. And then, so, did you talk to Sophie, or who did you talk to first?
I talked to mother first,
Okay,
Miss Hewitt.
okay. And then, so did you go into the house?
Yes, ma'am.
Okay. And what did you observe as you were there in the house?
I've observed clutter, chemicals on the floor, trash on the floor, open baking soda in this bathroom, the middle bathroom, clothes all piled up in the child's room, food. Their kitchen was very dirty. There was canned food in there. I believe there was some snacks and stuff for them to eat. The
You go ahead.
okay. The freezer was stuffed full of just random things, very dirty as well. The fridge didn't have a light in on it. It was barely working, so a lot of their stuff was in the freezer due to the fridge not working. But she reported that she did tell her landlord that, you know, she's having problems,
Okay.
but they had not responded yet.
Okay. You were handed those photos. Are they familiar to you?
Yes, ma'am.
Okay. If you would just go over those, and do they fairly depict what the condition of the home was when you were there?
So they do.
Okay.
The picture of the kitchen that was taken at this point, the mother had already started cleaning up.
Okay. Okay.
So it was even worse than what
those
this picture
pictures.
is, yes.
Okay.
If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next one.